I will start by introducing our speaker, Professor Udo Schuklenk. Udo is the Ontario Research Chair in Bioethics and Public Policy at Queen's University at Kingston. Professor of Philosophy, Udo Schuklenk has been the editor-in-chief of Bioethics, which is the official journal of the International Association of Bioethics for the last 2 decades, and also an author or editor of books on atheism, bioethics, and health policy. Udo, thank you very much for joining us, and I will turn the floor over to you.
Okay, well, thank you, and good evening, everybody. And I just want to tell you that my brief was to talk for around 45 minutes. And I promise I will not talk longer, because I think a 45-minute talk on Zoom is a long time for most people, unless you dance or strip or do exciting things that entertain people. An academic talk is probably not falling into that kind of category of entertainment. So I'll definitely will not go over time. I'll try to be a bit shorter if I can. I wanted to talk to you today about something that I've been working on for the last few years, not only on this issue, but on this particular issue. I'm genuinely concerned about it, not just from an ethics perspective, but certainly also from a policy perspective. And that is the issue of the use and abuse of conscientious objection by the religious right in the ongoing culture wars. I will explain to you basically what kind of problems are rising at the moment. It's going through the courts at the moment in Canada, but we are not the only country where that's happening. What the implications of that will be for the delivery of healthcare. And after I give you the background, I then give you a more traditional ethical analysis of conscientious objection within bioethics. So I basically give you arguments in favor or in support of the view that we should accommodate conscientiously objecting healthcare professionals if they have good reasons, or if they're genuine for whatever reasons. I will look into those, and I try to show that each of these arguments fails, and that ultimately conscientious objection is incompatible with healthcare, or certainly with medical professionalism. So that is the objective. I think we have plenty of time to have a discussion after this, after the presentation. And I'll just start now. Okay, so that was the first button that didn't work. Oh yeah, okay, this one is working. So this is what I propose to talk about today. I want to quickly give you an explanation for why there is a growing controversy in the first place. Given that conscientious objection, of course, is a much older thing. In fact, it goes back literally hundreds of years. In all sorts of contexts, we have conscientious objectors. Today, the only place where it is really like a hot button topic is in healthcare practice, strangely. I'll then talk about the history of conscientious objection, and there my primary aim is to show that the historical debate about conscientious objection does not map at all on conscientious objection in healthcare practice. These are two different kettles of fish, and we should be really careful not to conflate these two. And again, there are both historical reasons for that. There are also political reasons for that. So having set the scenes then for the discussion, I hope, and explaining the problem, I'll talk briefly about what conscience actually is, whether we can actually get a handle on that, or whether it just means I feel strongly about something and now give me rights as a result of that. I then look at standard arguments in favor of conscientious refusal or conscientious objection, or conscientious objector accommodation, and give responses to that. I'll then look at the question of what could be reasonable lines that one could draw in the sand if one wanted to limit conscientious objection. Because, to be fair, not everybody who is a conscientious objector is like some complete fanatic and just insists that they get their way and nothing else matters. And there are people who have proposed that if people are really genuine, then maybe they should be accommodated. I want to look at that. And others have proposed that we should accommodate objectors who are reasonable objectors by some definition of reasonableness. I want to look at that too. I then want to discuss 3 possible alternatives to conscientious objection that Julian Savulescu at Oxford and I have proposed. And I want to conclude with arguing in Canada, pretty much like in any other country, there should be no accommodation at all of conscientious objectors, and that in fact would bring us in line with other liberal Western democracies like Sweden, for instance, like Finland. So we would not be complete oddballs if we decided to go down that road. In bracket, that's a pipe dream. The courts here will decide differently. Whatever I think about it doesn't really matter, but at least I mount the argument. That's what I think academics should do, think about these things. Okay, so that's the agenda. I want to be clear what I'm talking about when I talk about conscientious objection accommodation. I'm looking specifically at a situation where we have healthcare professionals, that could be doctors, that could be nurses, that could be people in the allied healthcare professions, physiotherapists, for instance. It could also be pharmacists, any of these people that are healthcare professionals. What characterizes them as professionals? Fundamentally, they have a monopoly in the provision of these particular services that are in question, that are contested. So I'm concerned then about a situation where such a person, such a monopoly provider of a particular healthcare service that is legally permissible and is requested by a patient who, by the standards of that society, is eligible to receive that service. Think about medical aid in dying. You're autonomous in Canada, you meet the criteria, you ask for it, and then somebody says basically, go away, I don't care, I'm not going to do this anyway. And that person is the monopoly provider of these services. So when these people basically request accommodation for a denial of this service, that's what I'm concerned about. And nothing else. So I'm not concerned about a situation where, say, in Guantanamo Bay, a nurse refuses to participate in force feeding of prisoners who are on hunger strike. Why? Because the patient in this case, or the prisoner in this case, did not request the force feeding. So it's really important to understand that the concern here is about patients that are eligible to receive a legal service in a particular society, and then the healthcare professionals refuse to provide it on grounds that are non-professional grounds, that are grounds of an idiosyncratic private other nature, whether it could be religious, but it could also be ethical, it could be any number of convictions, okay? So why do we have a controversy about this today in the first place? Ironically, and maybe not that surprisingly, for the last few decades, the only people affected by this as a phenomenon in healthcare provision were pregnant women. They were told basically, usually by guys, that they would not receive an abortion. And unsurprisingly, most guys didn't really care about that. And as a result of that, there was no really political or legal attention spent on conscientious objectors in the healthcare profession. That's has changed now. What has changed? What has changed essentially is that in liberal Western democracies, essentially civil rights activists succeeded in establishing healthcare services in a number of areas that are still contested, but where they won basically. It was a political war, it might have gone through the courts, it might have happened in the parliaments. And these other areas are, in particular in Canada, of course, end of life care, medical aid in dying. It also includes care for essentially queer patients, looking for in vitro fertilization, for instance, or other artificial means of reproduction. It could affect transgender patients looking to get surgery, for instance, or other care that has to do with their gender reassignment. It has reached the stage in the United States where today they have legislation in place that effectively permits healthcare professionals to refuse care to such patients, even in life-threatening circumstances. It could be a situation where you're the only person able to provide an abortion and where the pregnant woman's life is at stake and you refuse it anyway. It's of no concern to you. It could simply mean that you are part of the emergency medical response, and there's a transgender patient who refuses to touch them because you are opposed to transgender people, period. It could be something that it could be, these are all situations that are already occurring. I know of another situation to do with enhancement drugs, for instance, that say might improve your memory, like modafinil or any number of other drugs. I have heard this in the context of a consultation that the pharmacists, the college in New Brunswick, they had a consultation about this. And one of the pharmacists there was quite clear. She said, well, I don't really care whether somebody gets a prescription for modafinil. They're not getting it from me because I'm opposed to enhancement. So her view was basically that she could stop, even if a patient comes, in other words, with a valid script from a doctor, she would still not provide it because she believed she had a right, a conscience right, not to provide these medication, even if she's the only pharmacist in town. She didn't really care. So what I'm trying to explain here is basically that this has moved really rapidly and really quickly beyond reproductive health issues into all sorts of other areas of healthcare services, where healthcare professionals decide, I feel strongly about this, they're not getting this from me. And so at the same time, then patients can't go anywhere else because they have a monopoly in the provision of these services, these people, and there's a problem. Also importantly, their refusal to provide these services each time is not a professional refusal. It's always a refusal that is based on conscience, and I will be talking a bit more about conscience. Now, Alta Charo is a law professor in the United States at the University of Wisconsin in Madison, and she has been on the Clinton's National Bioethics Council. Don't hold me to what the name of this thing was at the time. She wrote an article in the New England Journal of Medicine where she said, and I quote here, claiming an unfettered right to personal autonomy while holding monopolistic control over a public good, in this case, the provision of healthcare services, constitutes an abuse of the public trust, all the worse if it's not in fact a personal act of conscience, but rather an attempt at cultural conquest. And this is the context in which I want to discuss this, because it is actually part of ongoing culture wars that are being fought across certainly the global north, but increasingly also the global south. Let's see. So what's happening is now that actually many of these, sorry, I'm checking every now and then my time so that I'm not going totally over as I promised. So many conscientious objection claims are part of well-organized campaigns by political campaign organizations to subvert hard-fought over civil rights, patient rights. And these are today occurring in the areas of abortion care, in the context of contraceptives, and in the context of contraceptives is both doctors and pharmacists. In the context of end-of-life care, it is doctors, nurses, and pharmacists who might refuse, for instance, and ultimately to deliver the script on particular medication that people might have to take in the context of assisted suicide. I mentioned already queer patients where it could affect them in the context of access to in vitro fertilization, but also, believe it or not, recently a case was reported in the United States where a gay man, a student, postgrad student at a university, went to the campus doctor and asked for PrEP. PrEP is pre-exposure prophylaxis, which is basically for people who don't want to use condoms or can't be sure that they all the time use them properly. So in effect, it's a drug-based barrier to acquiring an HIV infection. And the doctor basically said, I'm opposed to your sinful lifestyle in the first place, and I am not prescribing pre-exposure prophylaxis to you. That's your problem. You're not getting this from me. Even though this person, this gay guy, was the exact target for this kind of medication. That's what it's designed to do. Again, not a professional judgment. It was entirely a religion-based. It was a Catholic university where this happened, the Catholic University Health Service, where the doctor said, no, this is sinful by my standards, and so you're not getting this, even though it might be the standard of care that is otherwise considered the professional response to these sorts of requests for people like you. So how does this fit into the culture wars? It fits into the culture wars because here's what's happening, and I'm referring here to, it's a brilliant article. I highly recommend it to you if you have the time to read this. Douglas Najim and God knows what the first name of Siegel is, they published an article in the Yale Law Journal in 2015, where they were looking at how evangelical conservative religious groups in the United States use the strategy, the constitutional protection of religious freedoms and conscience to subvert patients' access to care and ultimately permit patients the ability to basically exercise their rights that they fought over so hard. So they have looked at healthcare refusal laws that have sprung up all over the United States, and that they, of course, also try then to see in other countries. And this is why we have lawsuits occurring right now by religious doctors associations in this country to achieve the same objective. So healthcare refusal laws allow doctors or nurses to refuse to treat patients. Here's the kicker. And this is the law in a number of states in the United States already because of this. To refuse to treat patients even in emergency situations, and do so without requiring that healthcare professionals provide advance notice of their objection to their employer, so no planning is possible, so that the patients receive needed care by other means. In addition, some of these laws allow healthcare workers and institutions to refuse to provide referrals or information that would notify the patient of the availability of alternative care. So say this student, if he had not been well educated, he might have gone to the doctor and explained that they have whatever issues with condoms, and they're trying to get some medication that they heard about, and the doctors might just say no, and they would assume, well, then maybe this is not for me, because they do not even receive the information about what the fact of the matter is, the clinical fact of the matter. And this legislation permits them to do that. They also point out in this review article in the Yale Law Journal that the assertion of conscience claims in culture war conflicts is really a transnational phenomenon. That's true. We have it in Canada, you would find it in Jamaica, you would find it in Uganda, you would find it like all over the world these days. It is well funded and it's global. And it's a response really to civil rights activism that has succeeded on a number of fronts that these people find really painful. And the organizations and activists encouraging these claims work across border. You can show this, that these on the left-hand side of this slide here, Americans United for Life, for instance, work with well-funded conservative Christian groups in Europe, for instance, who went to the European Cause of Human Rights to fight exactly the same claims. So it's happening all over the place at the moment. So Americans United for Life is one of these organizations. They have successfully drafted model legislation that was aimed at enshrining conscience right in state laws across the United States, with some of the consequences I've just outlined. So here's where we are in Canada, and I'll just give you one example. In Canada, you will know, of course, that thankfully we have no restrictions on abortion access. We can have an argument about this, but right now I just assume that's a public good, that's a good thing for women. Most abortions in this country, as a matter of fact, are provided by family medicine practitioners. Now we have empirical evidence published in medical journals. Last year, I can send the paper to you if you have doubts, it's not a problem. 80% of Canadian residents, like the new doctors, new generations of doctors in family medicine, have not witnessed or observed an abortion in the course of their residency. It doesn't happen anymore. Why does it happen anymore? In this study, Susan Phillips, who is a senior family medicine professor here at Queen's at my university, she says essentially what happens is that Canadian medical schools have capitulated to conscientious objectors. They don't want the hassle, they don't want the noise in their units, they just want to get on with peace, because that's how we are in Canada. We are not confrontational, except me, but we're not confrontational. We're all wonderful, nice people, and we are polite to each other. So nobody wants the conflict. As a result of that, each time a unit thinks, oh, there might be an objector, it is just not addressed, it doesn't happen there anymore, and there's no training occurring. So what she's charging effectively is that Canadian medical school programs are putting accommodation of the individual learner or teacher who might be an objector ahead of publicly held values and standards, in this case, the provision of abortion services in this country by family doctors. So in 10 years' time, if this continues and you go to a family doctor of those people who graduated basically over the last 10, 15 years, they have not received any training any longer in this. This is where we are at this point in time. This is how this looks like in other countries. In Italy and Portugal, where gynecologists are tasked, unlike family doctors here, but where gynecologists are tasked with the provision of abortion services, 70% of gynecologists are on the books as conscientious objectors. 80%, oh, sorry, the second slide was supposed to say 80% of Portuguese gynecologists are conscientious objectors. So with those numbers in Italy and Portugal, what you have, of course, you have a massive number of backstreet abortions that you try to avoid, of course, from having by tasking these people, giving them monopoly and training them doing all these things as a society. So the upshot of this is, if the number of successful conscientious objectors who hold such monopoly in the provision of particular services is sufficiently high as it is in these countries, patients' rights might be on the books, on the legal books, but they have been successfully subverted. That's where we are, and that's, I think, where the train is going unless we're not really careful. What is interesting about this, just to me, like as an old-fashioned small L liberal, is that in the old days, us liberals would have always argued, you know, that minority rights ought to be protected against the dictates of the majority. For instance, protecting queer people against religious conservatives. They were mainstream at the time, but today, of course, they're not mainstream anymore. So here's the kicker, they're using the same arguments now. So this is what I call liberalism turned upside down. So the majority seeking to enforce traditional morality has now become a minority. But of course, they are just as keen as before to dictate their views on morality to everyone in society. So they now, in court cases, including in Canada, appeal to values that traditionally they despised, which were pluralism, toleration, and non-discrimination, which were prominent amongst them. So conscientious objection today, like respect us, respect our morals, our convictions, all these things, is now the tool that is utilized to achieve these objectives. But the objective remains subvert fellow citizens' ability to enjoy their rights to their traditional conservative views. Here's the evidence that I think, I mean, there's more evidence for this, but for Canada, it's like, here's a beautiful example, I think. You know that healthcare in Canada is publicly funded. So at the same time, we have like boatloads of Catholic hospitals. In many places, they're the only hospitals. And they, of course, are all claiming that their conscience rights must be protected. In brackets, they're really telling us, you know, that a hospital building like infrastructure has conscience rights. It's completely bizarre, but that's where we are. Here's the kicker, which to me suggests that this is really about strategy. It's about a political strategy. Because these same institutions, not for a moment, hesitate to disregard their own healthcare workers' actual conscience rights when they wish to provide these contested services. They fire them. That's when you know that these institutions and these claims are about a political strategy as a claims. Because apparently, in their view, conscientious objection claims should only be respected if they align with traditional conservative religious edicts. Another example from the United States, published in a peer-reviewed journal. Doctors who disapprove of the use of contraceptives resort to ever more devious methods to prevent women from access, for instance, by insisting that women who had never had sex undergo pap smears before they would prescribe contraceptives to them. So it just means basically another hurdle that's put up in front of women before they can access contraceptives. In brackets, why contraceptives are not over the counter beats me, but that's another issue. And I mentioned earlier, doctors have also refused to provide PrEP to gay men to prevent them from having unsafe sex or from having any sex at all, for that matter. So let me talk briefly about the history of conscientious objection. I do this really briefly, even though I'm going back to the year 295. The first known conscientious objector is a guy by the name Maximilianus, and apparently his name was only Maximilianus. So I don't know whether this is first name or last name. It's Maximilianus, for crying out loud. So this guy was the son of a Roman army soldier. And he refused to join the army, and of course he was executed. And he did it on grounds of conscience. We know more recent examples, of course, of conscientious objectors. Think about Quakers or other pacifists during the Nazi reign. Hermann Stör, for instance, was the leader of the German pacifists, and he was executed by the Nazis. What is interesting here is, of course, that when you would really need to protect conscientious objectors, which is never in liberal democracies, respect for conscientious objection counts for nothing anyway, because the Nazis, frankly, didn't give a shit about conscientious objection. They just killed them, and that was the end of that. The irony is that the only time when conscientious protection of values supposedly matters is, ironically, liberal democracies, where people have but it's only here where we actually care about that and discuss it too. So here's how now my internet connection is unstable. That's really great news. I hope you can still hear me. If not, just somebody wave their hands. So international documents that are really important in this context is from the United Nations, the Covenant on Civil and Political Rights, which stipulates with regard to these passages, use lethal force, freedom of conscience, and the right to manifest one's religion or beliefs, then people ought to be protected. That's the idea. I don't want to read all of this to you. You can do this some other time if you want. The upshot of this is this, right? They're saying, first of all, it is true. Religious freedom, freedom of thought, freedom of conscience are important values, and they ought to be protected. Everybody today suing in support of conscientious objection accommodation reads this on the left-hand side of this slide as an absolute right, like an unfettered right to have their conscience views, whatever they are, on whatever kind of professional service, respected and accommodated. The thing is that the same document actually says something that limits these kinds of claims. They're saying, of course, the freedom to manifest your religion or your beliefs or your ethical convictions or whatever they might be, of course, may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals. And this is exactly where the conflict lies. Where do you draw sensibly the line between protecting these rights and protecting others who might be affected by somebody then acting on these rights, right? That's the conflict. And this is the same situation that we have in Canada. We have what you see on the left-hand side basically is covered in the Charter, and what limits it on the right-hand side, we also have that in the Charter. And so rightly, this right now is going through the courts here, but this is sort of where we are right now. And in brackets, the Canadian upshot of it all will be very Canadian, which means probably it will be a requirement of effective referral, which is not working anywhere. But okay, I'll get to that later, I hope, depending on how much time I have. So the reason why what I have just talked about doesn't map on healthcare professionals is because there's a big difference between Maximilianus being forced to join the army or the Quakers in Germany being forced to join the Nazi forces, and doctors fighting tooth and nail to get into medical school and volunteering to do their job and becoming professionals. That's a very important difference because medicine is not conscription. You make a voluntary choice to provide these services and become a monopoly provider to society. And this is what doctors in fact promise. They're not promising whenever I feel differently, I don't provide this service. In fact, in their graduation oaths, this is what they actually promise. And I'm using here from the World Medical Association a thing called the Declaration of Geneva, which is the modern equivalent of the Hippocratic Oath. And this is what they're saying. I solemnly pledge to dedicate my life to the service of humanity, i.e. the public good. The health and well-being of my patient will be my first consideration, not I come first. I will practice my profession with conscience and dignity and in accordance with good medical practice. Believe it or not, the World Medical Association added in accordance with good medical practice because doctors were quick to point out, I will practice my profession with conscience, and thought this is what it means. When my conscience comes in, I can override all these other obligations. And so now they clarified it and said very clearly, you ought to be conscientious about acting in accordance with good medical practice. Believe it or not, that had to be put in there because otherwise doctors decided this doesn't apply to me any longer, the good medical practice. Yeah. So conscience must coexist with good medical practice. It doesn't trump it. In reality, though, conscience claims only occur in liberal democracies when a healthcare worker asks precisely for permission to act unprofessionally, because otherwise you would not need conscientious accommodation clauses. If a doctor knows what their professional obligation is, then they ought to act on that professional obligation. You only need to use conscientious objection if you know what your professional obligation is and you don't want to live up to it, so you need some other excuse for that, this is where conscience comes in. It's really important to understand this. Nobody is saying a doctor can't make a professional clinical judgment not to prescribe a certain drug or to do a certain thing or not to do a certain thing. That's not the issue. The issue is that a doctor knows that this is their professional obligation, but they don't want to do it for other reasons. And this is where the conscience claim comes in. And this then leads me directly to what is called the incompatibility thesis. Unlike professional refusers, which is people who refuse to provide a service on a professional ground. A perfect example is you go to the doctor with the flu and you say, can I please have antibiotics? And the doctor says no, because antibiotics do nothing with viruses. Flu infection is a viral infection. It makes no sense to prescribe antibiotics to you. That's a professional refusal to give you that script. So unlike professional refusers, though, conscientious refusers decline to provide particular professional services based explicitly on rationales that are not professional judgments. It's the opposite. They know what they should do and they don't want to do it. So these actions are motivated by judgments that are conscience-based as opposed to professional judgment or clinical judgment-based. To my mind and to the minds of a fair number of my colleagues, professional conduct and conscientious refuser or conscientious objector accommodation are in fact incompatible. Conscientious objection accommodation destroys the very rationale for why we as societies have healthcare professionals in the first place, why we gave them a monopoly in the provision of these services. They promise to serve the public good by being reliable monopoly providers of these services. And the public good is not served by what in the end would be a healthcare delivery lottery. That's what it boils down to. Caroline McLeod, good friend of mine, good colleague of mine, has just published a book, literally last week or the week before, called Conscience in Reproductive Healthcare, where she mounts the argument that doctors really are patient fiduciaries. And when you think about the doctor promising that the patient comes first, of course they are patient fiduciaries. So they must always act in their patient's best interest. And she argues in this book, it's a long book, so to summarize it in 2 bullet points, it's a bit unfair, it's more complex, the argument. But fundamentally what she's saying, conscientious objection claims are incompatible with this understanding because what's in a patient's best interest is clearly defined by a doctor's professional duty, the fiduciary obligation. So how am I going for time? Oh, I have 10 minutes left, right? Is that correct? Shauna, still there? She gone?
Yes, no, I'm here. Yes, you do have 10 minutes at least, yes.
Yeah, because I have another.
Well, you started late, so.
Yeah. Okay, but just shut me up at some point. All right. Okay. So what's conscience? Conscience, I thought, to be fair to the other side, I picked honestly, friend of mine, Daniel Somasi. He was a Catholic priest. He's married now, but he's still a staunch Catholic. So I'm using his definition of conscience. I'm not squibbling because I think he's right. It's a good definition. So he understands conscience as our conviction. He's also a medical doctor. Our conviction, he says, that we should act in accordance with our individual understanding of what morality demands of us, and on willfully, deliberately and voluntarily acting in accordance with what we consider to be morally good and right. And this can be acted both retrospectively as well as prospectively. Sorry about this. Not COVID, it's the allergies, allergy season. All right. So now I want to quickly rush through reasons that are given in defense of conscientious objection accommodation that are very prominent, that you will find also in court cases, and give you my counter arguments, and then we hopefully have a good fight over that or argument over that. The first argument is an argument that Mark Wickler, but also Christopher Cowley, whom I cite here, is the argument from personal integrity. Cowley argues here, he says, healthcare professionals being forced to act against one's conscience can result in a loss of integrity. No, I'm not winning here, hang on. It's not vodka, by the way, it's water. So, and this in turn leads to strong feelings of guilt, remorse, and shame, as well as a loss of self-respect, to people dropping out of the profession, or if they know their integrity will not be protected, to not entering the profession in the first place. So I think he's right, but there's a different answer to that. There's another answer to that that I think is fair enough, which is to say, don't join a profession where the delivery of some of its core services threaten your integrity. Do something else. Like I'm a vegetarian. I would not become a butcher for crying out loud. There's some things I just don't do. Nobody forces you to become a doctor. If you don't want to do this job, do other jobs. There's nothing wrong with that. The other important part is that really vulnerable patients are the weaker party here. Their access to services surely should take priority over a professional's integrity issues, given that these people are highly paid and they could do something else. Here's another variety of this argument provided by the American Medical Association's Council of Ethical and Judicial Affairs. They're saying, asking doctors to discard their professional conscience at the door to the clinic would have detrimental impact on professional integrity. So my question here is simply, how would doctors contribute to the integrity of the profession when they prioritize their private non-professional beliefs over their professional obligations? To me, it sounds like a contradiction in terms. They refuse to provide professional services to eligible patients that these patients request and they're monopoly providers of. So how is protecting them in doing that is improving professional integrity or the integrity of the profession? It seems a contradiction in terms to me. Here's an argument by Jocelyn McClure and Isabelle Dumont at the University of Montreal. They're charging, and I think they're right, we limit people's equality of opportunity by forcing them to choose between following their conscience or the profession they desire to join. So here's what I think are possible responses. The first one is, like before, patient access to care is of greater importance than protecting equality of opportunity of people who are affected by the deliberate and voluntary adoption of particular personal beliefs that are not intrinsic to their profession, to the profession that they intend to join. The other thing is, frankly, and I used myself here as an example, limitations on our equality of opportunity arise all the time. For instance, you can't see this, but I have a permanent tremor in my hand, right? That limits my equality of opportunity to become a neurosurgeon or a dentist for crying out loud, because it would be horrible for any patient that I would work on. So for that reason, I knew this is not a career prospect for me. Unlike what you might want to describe as a disability of sorts, in this particular instance, people choose these values. So you cannot, after you choose these values, turn around and saying, hey, no, I can't do this any longer. You volunteer to choose these, you make choices basically and accept the consequence of these choices. It's also the case that nothing would stop somebody from joining the medical profession, but then going into areas in that profession where they have to provide this service in the first place. Become a skin doctor, do x-rays. There's a number of things you can do, but do not join those parts of the profession that is tasked with providing services that then you don't want to provide. Here's an argument that I find bizarre, but I'm providing it anyway because, as I said, they are flipping the liberal old arguments around to their advantage now. So they argue from a loss of diversity. They said, well, if people like us could not join the medical profession any longer, there's a big loss of diversity. So certain individuals might just not join the medical profession if these conscience claims were not readily accommodated. So my take is, so what? That's good news. Not all diversity is good diversity. It's a bit like saying, hey, if we also had the chance to get lots and lots of racists into the medical profession that refuse to treat, I don't know, Jewish people or black people or whatever people, right? That loss of diversity is not a problem. It's good because people get the services that they require and they get them in a non-judgmental manner, and that's great. So there's no evidence, in other words, that patient care, and this is the primary reason for why we have the healthcare profession. There's no evidence that patient care would suffer if the refusal to accommodate these objectors would lead to some people deciding not to become medical professionals. They would just do something else with their lives, become astronauts or bus drivers or professors like me, and that's fine. That's great. The objective of professionalism is to aim at providing uniformly certain services that these people are the monopoly providers of, and society relies on them to do that. And that's the deal that we have basically as society with our professions. So the reason why we have professions is that their members serve and maximize the public good. And conscientious objection and accommodation does exactly the opposite of this. So I now go quickly through two other arguments where people would say, okay, fine, maybe we need to find some limitations on this. Fettered accommodation. So one strategy was to say, well, we should only accommodate those that are really genuine about it. I don't know, I'm losing it, my throat. So it is true that the courts in this country, for instance, try to determine whether somebody is a genuine conscientious objector. The problem is that, of course, we can never know this. We can just know whether somebody can persuade a court or I can persuade you, but do we know what's going on in people's brains? We have no idea. So they can tell us lots of things. The other point I would like to make is that there's also genuine Nazis. So the fact that somebody's genuine about their beliefs doesn't mean they're valuable beliefs. And we need to take a stance on whether these views are worth protecting, not that people have them. There's evidence that conscientious objectors are lying. In Uruguay, for instance, conscientious objection to abortion care in public health facilities is 53%. In private healthcare facilities is 27%. What's the difference? The pay rates in private healthcare facilities are much higher. So if you throw money towards conscientious objectors, they forget about their objections. Many of them, not all of them, to be fair. Some Canadian doctors have gone on the record of saying that they would not provide medical aid in dying because they're not paid enough for that. I'm not making this up. It has been reported in the media. I don't know the numbers, but you have to take these claims with a grain of salt. Conscientious objection claims, that's all I'm saying. And we can't test it really. Because I'm out of time, other argument, reasonability. The argument is basically, well, what if these claims are reasonable? I just wanted to say that in liberal democracies like ours, we cannot test the reasonableness of these claims. Why? Because if they were reasonable, it would be a professional clinical judgment. So by definition, there is something unreasonable in a clinical sense. So it will be a religious view or an ethical view or whatever kind of view. It's not a clinical judgment. Now, if that's the case, the courts can't take a view on this because it is not the role of the court to say whether your religious beliefs make sense or not. It's impossible in a pluralistic liberal democracy. They can't do this because then they would say, your religion is right. This makes sense. And the courts, both in Canada and in the United States, rightly have refused to do this. It's not the role of the court or any government for that matter to take a stance on these issues. So in other words, we can't test the reasonability claim of conscientious objectors. So last two slides, I think, yes, last two slides. Julian Savulescu and I have argued in a paper that is open access, so I put the link up on the slide. Well, we said basically what we should be doing is to get rid of this problem. There are several options. The first is, my favorite, restrict entry to medical school or specialty training to those willing to provide the relevant services. If they don't want to do this, let somebody else in. The queue is so long that you will find enough people willing to actually do the job, and let the others do other things. Secondly, and basically like in Sweden or Finland, make clear right at the beginning when people join medical schools that there won't be any accommodation for conscientious objection. Yes, you can go to your colleagues, you can ask whether somebody is willing to do this for you, but you have no claim right. It's a different thing to say, yeah, I'm happy to help you out here because you don't want to do this procedure or that procedure. That's all fine. But no healthcare professional has a legal claim right to say, I'm not doing this, you must accommodate me. Other possibility is, of course, I think it's ludicrous, but another possibility is to say demonopolize medical services that are contested. Because very quickly we would not have a medical profession any longer because everybody who objects to something could then say, we demonopolize this. So abortion over the counter, modafinil over the counter, we give everything is a free for all. Libertarians might think that's a great idea. I think Health Canada think that's pretty ludicrous. So that's probably not an option. Yeah, and as I said, the proposition already, remove the legal right to object to certain duties and deal with objections then simply under labor law. If you don't want to do this, you cover this under labor law. Just like me, for instance, saying, I don't do online teaching. because I think it's suboptimal pedagogically and whatnot else, right? And we all realize this is not an ideal setup that we have right now. So Queens could fire me over this, and I think that's the right thing. It can't be that I have the last word on this. So why should there be no accommodation? I need to introduce one additional argument to you, which I think is very important. The others I've covered, and it's an argument from equal citizenship. If we have a cast of people that have a monopoly in the provision of particular services, and these are not just doctors, it could be police officers or judges. And these people, on grounds that have nothing to do with what they do professionally, would be able to deny us as citizens access to our right, to access to our rights, like access to healthcare services or access to equal treatment under the law, then our standing as equal citizens is of course undermined, because it means that somebody on grounds that are not police grounds, not legal grounds for the courts, not healthcare grounds for the medical profession, could basically deny me, basically could deny me access to services that I'm legally entitled to. And that means I cease to be an equal citizen. They have the last word, and that can't be. I've covered the other things, so I will not go over that again. And here's just a bunch of further readings. If you want to, stuff I've published on this in medical journals and bioethics journals, I can send those to you if you care. On the first slide, I had my my email address and my Twitter. So if you email me, I can send that to you, and then you can read up on some of the details in case you missed any of that. So thank you.